Hearing in the appeal of the Queen on the application of Wang Yam and Central Criminal Court and another.
Good morning, my lords and my lady. I appear with Kirsty Brimelow and Nicholas Grubeck for the appellant Wang Yam, and James Eadie and Jonathan Hall appear for the Attorney General. The court will have seen that the appeal concerns the legality of restrictions on the appellant's communications with the European Court of Human Rights. Mr. Wang Yam has been convicted of murder. The trial judge, Mr. Justice Ousley, ordered that part of his defence case be heard in camera because of national security considerations. The appellant has complained to Strasbourg that his trial was unfair in breach of Article 6 of the European Convention on Human Rights for various reasons, including that part of the case was not heard in public. The trial judge has prohibited the appellant from informing the European Court of any of the sensitive material. That is the material heard in camera. The Divisional Court upheld that prohibition, and we say the trial judge had no legal power to make an order prohibiting disclosure of this sensitive material to the European Court. My lords, my lady, can I summarise our case in 4 propositions, which I will then seek to develop in the time available to me?
Yes, of course.
First proposition is we say that this country has an international treaty obligation to allow the appellant to communicate freely with the European Court to present his application. It's based on Article 34. The second proposition is we say it is a principle of the common law that the courts will seek to interpret both statutory provisions and the common law itself consistently with the international obligations of the United Kingdom. And this is still the second proposition. In the context of human rights, that principle means a strong presumption that statutes and the common law will be construed and applied consistently with our international human rights obligations, unless Parliament has stated expressly or by necessary implication to the contrary. Our third proposition is that in the present context, Parliament has not conferred a power on the courts expressly or by necessary implication to restrain the appellant from communicating his information to the Strasbourg Court. The fourth proposition is I need to deal with the Attorney General's emphasis, it's paragraphs 11 and 26a of his printed case, where he says if the appellant were correct, then there would be no power in the domestic court to impose a restriction, however grave the risks to national security.
Yes.
The Attorney General says, it's paragraph 26 of his printed case, this would be, quote, both surprising and disturbing. And our answer will be that if the government does believe that the risks to national security outweigh the international obligations of the United Kingdom, it is open to the government to invite Parliament to confer a relevant power on the domestic courts. Or, of course, it's open to the government to decide no longer to subscribe to the convention, no longer to have the international obligation. Those are the 4 points I want, if I may, to develop. Before developing them, may I mention some aspects of the context in which the issues arise? And there are 4 contextual points. The first of them is this: the Strasbourg Court is treating the appellant's Article 6 claim as worthy of consideration on its merits. the court may have seen that the European Court has communicated the application to the United Kingdom government. Strasbourg invited the government to submit written observations on admissibility and merits. I noticed that the court does not have the document in which...
We've now got it in front of us, yes.
Indeed.
Thank you very much.
It's the final page of that.
Yes.
Contains the two questions to...
I think reference was made to it, but we haven't
Indeed,
actually seen
indeed.
it. Yeah.
But
Thank you.
Court, I apologise, the court doesn't have them in the Appendix 1 and 2, but the court now has them, the court has seen them. And of course, as this court knows, the vast majority of applications to Strasbourg, and indeed the vast majority of applications against the United Kingdom, are declared inadmissible without even being referred to the government for their written observations. So Strasbourg is taking the complaint seriously. Most recently, on the 27th of August of this year, the European Court adjourned the proceedings in Strasbourg pending the delivery of judgment from this court. That is in Appendix Part 2. I can just give the court the reference, and it's MS page 304.
Yes.
The ordinary numbering is 227. I'll give both numbers in each case if it assists, but it's MS page 304.
Thank you.
My lords, my lady, I do not propose to take time seeking to persuade this court of the merits of the Article 6 complaint. It suffices for the purposes of this appeal that the appellant has a claim that he is the victim of a breach of Article 6 rights, which the European Court is taking seriously. I say it is a matter for Strasbourg to assess the strength or otherwise of the Article 6 claim. The second contextual point that I want to mention is that, of course, the Strasbourg Court does have procedures for protecting the confidentiality of sensitive material which it receives in the course of considering applications. It would be surprising if any responsible court did not have such procedures. The relevant rules, if I can just give the court a reference, can be found in Authorities Volume 1, behind tab 7, which contains the rules of court in Strasbourg, and the relevant rule is Rule 33. It's tab 7 of Volume 1. Rule 33, it's MS page 474.
Oh, yes, thank you.
And I won't read it all out, but it's a rule that gives ample power to the Strasbourg Court to preserve confidentiality. In particular, see Rule 33.2, in the interests of national security.
Are you inviting this court to review Mr. Justice Ousley's decision that it was reasonable for Open Secretary of State to take the view that those precautions wouldn't be adequate?
No, I can't invite, no. I'm coming to that, my lord. My answer is no, but I'm coming to that. It's my third and fourth contextual points, but I can't. But just completing this second point, so there's Rule 33, and in addition, the court will have seen a letter from the section registrar in the European Court to the United Kingdom government. It's Appendix Part 2, MS page 205, internal numbering 128. MS page 205, where in the third paragraph the European Court confirms that the court has procedures in place to ensure the safe storage of secret documents should the need arise.
Sorry, what was the other number?
The MS page 205, the ordinary number 128, Appendix Part 2. It's the third paragraph, I can confirm.
Thank you.
So that's the second contextual point. The third background point is that, as the court have seen, the trial judge found, and indeed the Court of Appeal agreed, that the sensitive material should be heard in camera in the interests of national security and also for the protection of the identity of a witness or other person. I take that from the judgment of Mr. Justice Ouseley, the more recent judgment, 27th of February 2014. It's in Appendix Part 1, his Lordship's judgment, and the relevant page is MS page 101, ordinary numbering, Appendix Part 1, page 24. And if the court has his Lordship's judgment on the next page, that's MS page 102, paragraph 1, at the end of paragraph 1, the order, that's the order that the trial, part of the trial, be heard in secret, in camera. The order was made in the interests of national security and for the protection of the identity of a witness or other person. And his Lordship repeats that at paragraph 53, which is on MS page 113, 4 lines from the end of paragraph 53. His Lordship says the order was not made on the basis of a mere assertion by the prosecutor. The protected interests included national security, the protection of the identity of a witness or other person. And I cannot and do not challenge the finding that the sensitive material is indeed sensitive, and that it would be damaging to national security and other interests for it to be published. Indeed, my lords, my lady, I make clear that I personally have not seen or been told anything about the sensitive material. I say that not as a complaint, it's not a complaint, but I'm in the same position as this court. That's why I don't want to know what's in it. Ms. Brimelow, of course, and my instructing solicitor, Mr. Mullion, have seen the sensitive material that was the evidence at trial. So that's the third contextual point. I'm not challenging that this sensitive material is indeed sensitive. And the fourth point, which is the matter that my Lord Torson raised.
Do the issues, or do we not know this, do the issues in Strasbourg involve the Strasbourg court looking at the sensitive material on the appellant's case?
Well, of course, at the moment they can't look at it because we are prohibited from sending it to Strasbourg. And
I follow that, but on the appellant's case, he would like the court to see.
Oh, very much so. Indeed, that's why the appellant wants to send the sensitive material to Strasbourg, because he, the appellant, says, and I can show the court the references if necessary, that he cannot develop fully and effectively his argument as to why it was a breach of Article 6 to hear this evidence in secret unless he can tell Strasbourg what this material consists of. That's part of his case, which I'm not arguing today. My position is that is his case in Strasbourg. It's his defence case in the criminal trial, and he cannot at the moment tell Strasbourg what the substance of his defence case was and indeed is. The fourth point, by way...
That was a point that was rejected in England,
very much
in
so.
the Court of Appeal.
Oh, yes, it's been rejected by the Court of Appeal on the interlocutory appeal. Your Lordship may recall what happened was Mr. Justice Ouseley decided that the sensitive material should be heard in camera.
Yeah.
There was an interlocutory appeal which was heard by Lord Phillips and others, and that court rejected the complaint about the decision to have a hearing in camera. And that judgment can be found in Appendix Part 1, MS page 139. There was then the trial with the hearing of the sensitive material in camera. There was a conviction, and there was an appeal to the Court of Appeal presided over by Lord Hughes. Well, there were two trials, yes. There were two trials. The first trial, the jury couldn't agree on the murder charge, although they found my client
And is this
guilty.
the point that was thrown out as unarguable by Lord Hughes?
Lord Hughes was hearing an appeal from the murder conviction,
Yeah.
and one of the grounds of appeal was that in all the circumstances there had been unfairness to Wang Yam, the appellant.
The question I was asking was whether that point was one that was rejected as unarguable by Lord Hughes.
Yes, it was. Yes, he granted leave to appeal. This is MS page 157, paragraph 58. And at paragraph 58, the Court of Appeal gave leave to appeal on certain grounds, but not on the unfairness ground relating to a hearing in camera, because that was ground 2. And paragraph 58, they gave leave to appeal, although rejected the appeal, on grounds 1, 3, and a combination of 5 and 6. The answer to this question is yes, it was thought by Lord Hughes to be unarguable. So the point was then argued there, and now there is the application to Strasbourg, which raises very similar points. I respectfully agree, I accept, very similar points to those which have previously been considered by the domestic courts. And that's why I've emphasised Strasbourg is taking it seriously. It communicated the Article 6 complaint to the United Kingdom government, and I'm inviting the court to proceed on the basis, because we're talking about an issue of jurisdiction. I'm seeking to persuade this court not to decide this case on the basis that Wang Yam has no arguable Article 6 claim, because it is being taken seriously by Strasbourg. It's for them to determine, with great respect, whether there's substance in the Article 6.
Have they so far held that it's arguable? They haven't, have they?
No, they haven't. What they've done is they have referred the issue to the United Kingdom for its written observations. Having considered those and having waited for this issue to be determined, the Strasbourg court will then proceed to the next stage. They could declare the application admissible, they could declare it inadmissible, they could declare it admissible on some grounds but not others. We don't know yet.
Or they could ask to see documents.
They could.
They hadn't been asked.
They could indeed. They could indeed. But I repeat, I'm not asking the court to decide on the merits or otherwise of the Article 6 point. That's not why we're here, with my submission. The fourth point, by way of context, is that there is now also a finding by Mr. Justice Ouseley, that's the basis of this appeal, that the purpose of the in-camera order would be put at risk by disclosure of the sensitive material to the Strasbourg court. And Mr. Justice Ouseley based that finding on a closed schedule to a PII certificate. And we can see that from his Lordship's judgment, which in Appendix Part 1, if the court please would go back to Mr. Justice Ouseley's judgment, which begins at Appendix Part 1, MS page 101. It's page 24 of the internal numbering, MS page 101. And in that judgment, if the court please would turn to paragraph 50, which is the start of Mr. Justice Ouseley's conclusions. And Mr. Justice Ouseley says this, he says, first, I accept what the PII certificate says. The certificate makes it clear that the circumstances which persuaded his lordship and the Court of Appeal Criminal Division in 2008 of the need for parts of the evidence not to be available to the public and press continue unchanged. Indeed, that was not at issue before me. The closed schedule, I emphasise closed, to the certificate also explains clearly why that material should not be made available to the Strasbourg court, whether or not it uses its procedural powers to impose restrictions on the availability of the material to the public or press. The purpose of the in-camera order would be put at risk by disclosure of the in-camera material to the Strasbourg court. This is not a case in which the problem can be resolved by cooperative attention to the mechanics, whereby the material can become protected by a decision of the Strasbourg court. His Lordship acknowledged a court should not stand in the way of what an applicant wishes to place before Strasbourg unless there's very good reason to do so. His Lordship had no doubt there are very good reasons to do so in this case. These are sufficient to prevent any question of judicial comity requiring this court to vary the order. and his lordship returned to the point at paragraph 59. I think that was good.
The relevant paragraphs
79.
in the open ministerial certificate
Yes,
are paragraphs 10 to 14.
they are.
At the very end of Appendix 1.
Indeed. They are in general terms. They provide no detail. And his lordship, Mr. Justice Ouseley, emphasised in the paragraph I've just read, paragraph 50, and he returned to the matter at paragraph 79.
When you say they're very general, I mean, the Foreign Secretary said, didn't he, that the details given for the benefit of the court were in the scheduled certificate.
Yes. Yeah. And that's what Mr. Justice Ouseley focused upon.
And he, of course, read the certificate
Yes.
schedule and concluded that the Foreign Secretary was entitled to take the view he did.
Indeed.
As well, gave his
Indeed.
reply to it. The Divisional Court, for reasons were not asked
No, indeed.
to do the same exercise as Mr. Justice Ouseley had done.
Indeed. Paragraph 50 emphasises the closed schedule. Paragraph 79 is the other paragraph I should draw attention to. It's the final sentence of 79. The closed schedule to the certificate provides a sufficient justification for the order covering applications to Strasbourg. Paragraph 79, the last sentence of that. Now, I emphasise none of the appellant's legal advisers has seen that closed schedule. And Mr. Justice Ouseley himself noted that at paragraph 5. It's the end of paragraph 5 of the same judgment, which is MS page 103, page 26 of the original. End of paragraph 5, this was supported by a closed schedule not seen by Ms. Brimelow, but she was aware of its existence. The Divisional Court, just so we're clear about this, the Divisional Court wrongly suggested that Mr. Justice Ouseley thought that counsel for the claimant had seen the closed schedule. They were wrong about that. The judge did not in relation to this. The Divisional Court were wrong at paragraph 6, MS page 85, just so there's no... it's clear that I'm not criticising Mr. Justice Ouseley in relation to this. If the court has MS page number 85, paragraph 6 of the Divisional Court judgment, we were end of paragraph 6, we were told by counsel for the claimant that although he, well, of course it should be she, knew of the existence of the closed schedule, she did not know what it said. The judge mistakenly thought that she had seen it. Well, he didn't.
It's not the schedule. It's
Yeah. Now, I just point out to
There's no challenge to that conclusion of Mr. Justice Ouseley, then, or is there?
that we hadn't seen it.
No, not that you hadn't. No, based upon the material he had seen.
Well, I can't challenge it because I haven't seen the material. None of us have seen the
Yeah, but
material.
there would be a mechanism for challenging it.
Well, indeed.
Within the English courts.
Well, indeed. I mean, the difficult...
But that hasn't been so far advanced. I mean, there would be a mechanism, would there not?
Yeah,
for challenging the decision of Mr. Justice Ouseley. No, am I right in thinking that nobody has so far sought to do that within the United Kingdom municipal system?
No, the position is this. I say it is very surprising indeed, and indeed fundamentally unfair, that Mr. Justice Ouseley should base a decision on a closed schedule which has been seen neither by any of the advisers to the appellant, nor has there been a special advocate appointed. I mean, that's the procedure if there's a sensitive...
That's not part of the issues before.
No, it's not. No, it's not. No.
I mean, I think Lord Clark's question is, would it have been open to you?
Yes. Yes.
And you didn't challenge it?
Well, in the divisional court, I'm told by Ms. Brimelow, the position is that we did not appreciate that there was a substantive material in the closed schedule until the judgment of Mr. Justice Ouseley. That's what I'm told by Ms. Brimelow. That is the reason. In the divisional court, the matter was explored in in the skeleton arguments, and the divisional court addressed the matter in their judgment at MS page, this is Appendix Part 1, MS page number 98. It's page 21 of Appendix Part 1, but MS page 98, at paragraph 59 and 60. And the divisional courts there say that if this point is to be raised, it can be raised at a further hearing. That's essentially what it comes to.
Sorry, can I just get one thing clear? Am I right in thinking that the appellant's legal advisors have had the ministerial certificate,
Yes.
not the schedule?
Yes.
And they had that before the hearing, before Mr. Justice Ousley?
They had it the day before, I'm told.
Because, did I hear you right, that they didn't appreciate that there might be matters of substance in the schedule?
Yes, Ms. Brimelow has told me that she and the others representing Wang Yam at the time thought the schedule just contained a list, that it didn't contain any substantive reasoning.
It's rather difficult to reconcile with paragraph 11 of the
Exactly.
certificate.
No. Well, I'm not inviting, I'm simply explaining to the court. It's not part of my argument. I'm simply explaining to the court, we are in this position.
Yeah.
I say it is, however this came about, and I'm not asking the court to make a ruling on it, however it came about is very unfortunate.
So, what you're saying, if I've got it right, is at that stage, getting at the last minute the certificate which actually says in it that there are full details in the schedule, application might have been made to appoint a special advocate, but for reasons that we needn't explore, that wasn't done.
Yes.
And so the matter went ahead with
And here we are.
everybody realising the judge had seen it, but others hadn't.
That's right. And here we are. I say that it is a fundamentally unfair procedure for the judge to have adopted, but we are where we are, and I cannot invite the court, and this is my answer to the earlier question by my Lord Torson, I cannot invite this court to proceed on any basis today other than that disclosure of the material, the sensitive material to Strasbourg, raises real national security concerns. This is a matter of real public interest and importance, because why does it raise real national security interests and concerns? And there are only two possible explanations. One is a concern about the efficiency of the Strasbourg procedures, that Strasbourg doesn't have a proper system for protecting security. And the other, I say this hypothetically because I've no idea, is a concern about personalities, that the people who are there cannot be trusted. Those are the only two possible logical explanations, and both of those, I say, are matters of real public importance. But it's not the issue
part
today.
of the same point.
I'm sorry, Lord?
Perhaps part of the same point.
Maybe. But,
Well, we actually know nothing, do we,
We don't.
about the Strasbourg,
We don't.
about the Strasbourg internal procedures. All they've said is that there are procedures for retaining
Yes.
material out of the public eye, and they haven't actually explained, and we don't know how matters are handled in the Strasbourg court, which is a very diverse court, and one would expect in a case like this perhaps that to have been investigated a bit more, but it hasn't been.
But it hasn't been. There's no open material, and there could be, saying, well, there have been problems in the past with Strasbourg and confidentiality, or these are the systems and they have the following concerns that we, the United Kingdom, have. I mean, there's nothing of that.
I mean, there's another point, isn't there, that in the possession of the Strasbourg court, the judgment as to the national security of the United Kingdom is made by, I think, the President of the Chamber, or possibly might go higher, but it is made by someone who is outside this jurisdiction, and who is perhaps not as well placed to judge what is in the national security interests of the United Kingdom as someone
What
who
your
is
lordship
responsible.
says is absolutely correct, but of course it frequently arises that cases are determined in Strasbourg which raise profound national security issues, whether under Article 2 or 3 or whatever, and they are determined by this international body of judges, and indeed that's the whole point of having a European court system. But your lordship's right, of course. Anyway, what it comes to, if I can summarise our position, we say it's deeply unsatisfactory that the judge made his national security findings by what I say is a procedure that's inherently unfair. But I can't challenge those findings in this court on this occasion. And I've taken the view that the proportionality of the restriction, which is mentioned in the supplementary point that we indicated we may wish to argue, the proportionality of the restriction, it seems to us, is inextricably linked to the secret schedule, which we have not seen. And therefore, on reflection, I cannot pursue on this appeal the proportionality ground which is mentioned in our printed case. That's the position we've come to. If your lordship's...
it would have to been developed below, really.
It wasn't developed at all.
No, exactly, but it would have to have been before it could
Yes.
be raised here. Yeah.
Yes.
But so none of the steps set out in the second part of paragraph 59 have been taken.
No, they haven't. Not yet.
The problem arose in relation to undertakings the Secretary of State was asking for, the Attorney General was asking for. There was disagreement, but we don't know what happened after that.
No, and the position is that we take the view it's important for this court to determine the issue of principle, and depending on the answer, then it may be appropriate to go back to the divisional court to raise the issues that have been left undecided.
We discussed this issue, and our preliminary view was very much the same as that.
Well, that's our position, if it pleases the court.
Thank you.
That's our position. Can I then turn to the substantive issues? And the first issue, the first part of that is, as the starting point, we say that the United Kingdom has an international law obligation to allow the appellant unimpeded access to the European Court. And our case is based on Article 34 of the Convention. Can I take the court to that? It's in Appendix, in Authorities Volume 1, and it's behind tab 5.
Thank you.
The court will find the Convention, and the relevant article, Article 34, is on MS page number 396. Article 34 of the European Convention, Volume 1, tab 5. Article 34 is headed Individual Applications. The court may receive applications from any person, non-governmental organisation or a group of individuals claiming to be the victim of a violation of one of the high contracting parties, by one of the high contracting parties, of the rights set forth in the Convention or the protocols thereto. The high contracting parties undertake not to hinder in any way the effective exercise of this right. And the court should also look, please, because it's relevant, at Article 38 over the page, because there's case law relating to that, examination of the case. The court shall examine the case together with the representatives of the parties, if need be, undertake an investigation for the effective conduct of which the high contracting parties concerned shall furnish all necessary facilities.
Can we assume at this stage that there would necessarily be a breach of those articles? I ask that question because presumably one question would be, which we certainly can't answer, in what respect, if at all, is the material actually relevant to the grounds advanced? Now, the Strasbourg court might take a view about that and might conclude that it was an obligation of the United Kingdom to supply the material, at least for preliminary consideration. But at this stage, we can't make any assumption one way or the other about that, can we?
I respectfully agree that the court cannot make any assumption about Article 38, and I'm not putting my case based on Article 38. It's a matter for the European Court to decide whether, and if so in what terms, to require the United Kingdom to supply information. My case is based on Article 34, which in my submission entitles the appellant, the applicant in Strasbourg, to put before the Strasbourg court such material as he thinks is relevant to his application.
There's no objective test of relevance, you say?
Well, I accept if what he wants to put before them is manifestly and absurdly distant, then maybe. But if it's something that is
That may
material...
be the contention put forward by the government.
Well, if it is, I will respond to it. But I say this material is plainly relevant to the questions that he's putting to Strasbourg.
And if the government takes the view that if he was able to do so, it would be very damaging indeed to national security, Article 34 would prevent them relying on it.
That is my submission. And can I show the court why I say that? There's a Grand Chamber judgment, Sisajiva, which is Authorities, Volume 6, tab number 37.
Thank you. Yeah.
Authorities, Volume 6, tab number 37, Grand Chamber, decision in 2007. And the court can see the context of the Article 34 point at the beginning of the judgment, paragraph 3. The applicants were alleging that the refusal of the Latvian authorities to regularise their stay in Latvia, despite their long period of residence there, amounted to a violation of their Article 8 rights. That was the context. And in paragraph 6, the applicants informed the court by a letter that the first applicant had been questioned by the police on the subject of the application to the court. And that was the basis of the Article 34 concern. The court began its assessment of Article 34 at paragraph 115, court's assessment.
Yep.
And they say at 115, the court reiterates, because it had said it on many previous occasions, that it is of the utmost importance for the effective operation of the system of individual petition instituted by Article 34 that applicants or potential applicants are able to communicate freely with the court without being subjected to any form of pressure from the authorities to withdraw or modify their complaints. And then there's some case law. 116, the word pressure must be taken to cover not only direct coercion and flagrant acts of intimidation of applicants or their families or legal representatives, but also other improper indirect acts or contact designed to dissuade or discourage them from pursuing a convention remedy. Whether or not contact between the authorities and an applicant or potential applicant amounts to unacceptable practices from the standpoint of Article 34 must be determined in the light of the particular circumstances in issue. In this respect, regard must be had to the vulnerability of the complainant and his or her susceptibility to influence exerted by the authorities. 117, in the instant case, the parties agreed that the first applicant was summoned to the headquarters of the security...
This is dealing with a completely different situation. Right. I mean, the whole thing is in the context of pressure, which is obviously extremely serious. So one doesn't actually know from this case what attitude would be taken to a case like the present.
Well, your Lordship is, of course, correct. I'm relying on the statement of principle at the beginning of 115, which is a broad statement of principle that Article 34... it's of vital, utmost importance, applicants are able to communicate freely.
No, but it doesn't stop there. It says without being subject to any form of pressure. And you can't read these cases by taking half a sentence.
Well, I'm happy to read the whole sentence without being subjected to any form of pressure. But the pressure on Wang Yam is that if he...
From the authorities to withdraw or modify. You're not suggesting that the British government's attitude here, or indeed the judge's attitude here, is to pressurise your client to withdraw or modify the complaints. It's a regrettable consequence that he may be in difficulty in pursuing it, though he may have another complaint about the current procedure, but it isn't designed to, using the word, to dissuade or discourage.
No, but it is designed to impede his ability to communicate freely with the Strasbourg court, and he is subject to a form of pressure, a very real form. The whole point of the order is to tell him, if you communicate freely with Strasbourg, you will be in criminal contempt. That's the substance of the order. I also emphasise paragraph 120, at the bottom of the page, the last two lines. In that connection, the court reiterates that even if a government has reason to believe that in a particular case the right of individual petition is being abused, the appropriate course of action is for the government to alert the court and inform it of its misgivings, etc., etc. And at 124, at the bottom of the page, taking into account all the relevant circumstances of the case, the court considers that there is insufficient evidence to conclude that the questioning of the applicant by an officer of the security police should be regarded as a form of pressure, intimidation or harassment which might have induced the applicants to withdraw or modify their application or hindered them in any other way in the exercise of their right, and I emphasise the word right, of individual petition. Now, I say that is a very broad statement indeed, and the whole point in my submission of Article 34 is to ensure that the applicant can communicate freely with the Strasbourg court so that it, the Strasbourg court, can decide what is relevant and what is important in determining the applicant's case. And I say this is of especial importance in a context such as the present, when the applicant is a prisoner challenging the legality of his conviction and subsequent detention under a life sentence. I say there's nothing surprising about the broad approach taken by the Grand Chamber to Article 34. I entirely accept that access to a court may be limited in a variety of ways. Limitation periods, a need for permission to appeal. But what is so novel about the present case is that a person with a right of access to the court, the European court, is being restricted as to what material he may place before the court itself. And we say that the essence of the right conferred by Article 34 is that the individual can place before the court such material as he, the applicant, considers to be relevant, so that the court, here the European court, may decide on the application of the relevant law. And I say, one doesn't want to be grandiloquent about it, but that's what the rule of law demands, whether it's in the context of a national court or an international court.
There are lots of circumstances in which a court, let's say a domestic court, may say, the party wishes to lay this material before us, but we rule that it could not possibly be relevant to the cause of action, and therefore you can't. And the Strasbourg court might say that, which is one reason why it's difficult for us to assume that there would necessarily be a breach of the last sentence of Article 34.
But I say what is so striking here is that in the example that your lordship puts to me, it is the court which has the material and which then is able to form a judgment on its relevance or otherwise. What is so striking about the present case is that the applicant is prevented from putting material before the relevant court so that the court itself may form a judgment on its relevance or significance. That is what is so unique. We are prevented from putting our case before the European court. And it's very difficult to think of examples in domestic proceedings where where that occurs. The court itself decides, even in the context of PII material. It's the court that decides. And what we are complaining about, what we say is so fundamentally at variance with a right to bring a petition, Article 34, is that we are prevented from telling the court what we say is needed by the court in order to pass judgment on the strength or otherwise of our application. That's what we're complaining about. And if this were a national context, I say it would be plain and obvious that of course the court must see the material in order to pass judgment on it. And in the international context, Article 34 is, we say, to be interpreted in the same way that the applicant must be able to communicate to a court that which he says is relevant to his application.
When you say the court must, if this were domestic, have the material to pass judgment on it, of course, in the context of criminal trials, occasions do arise when the court which is going to pass judgment on the issue, namely whether the defendant is guilty or not, is not allowed material because it's been slipped out. That may be on national security grounds or other grounds. The right at a domestic level is somewhat qualified, isn't it? Or maybe in national security situations.
But the court that is passing judgment on the relevance or otherwise of the material
is not the court which is making the decision on guilt.
That is, of course, I accept that, but nevertheless, the individual has a right for the court, in whatever manifestation it is formed, the judge, to see the material before a judgment is reached. That is what the rule of law requires. You're entitled to put your material before a court, and the court determines its relevance or otherwise. I entirely accept if the judge says this is not relevant, then it will not be seen by the court that is going to determine the issue. But in the European Court of Human Rights context, which we are here concerned with, our complaint is that we're not entitled to put what we say is the relevant material before any manifestation of the European Court.
Are you saying that that is an absolute right? I mean, you are saying that because normally domestic courts seek to give effect to the international obligations of the United Kingdom, therefore, Mr. Justice Ousley should have striven to give effect to the last sentence of Article 34 of what is an international obligation, not part of domestic law. And are you saying, therefore, there are no circumstances in which he could conclude that that international obligation was ousted or outweighed by a compelling domestic consideration?
I am so submitting in relation to Article 34. I say Article 34 is absolute.
Yeah, well, it may be absolute in international law terms, but we are considering whether an international law obligation should be given effect at the domestic level. And at the domestic level, there are other considerations like national security. And if the judge concludes that national security cannot be protected by giving effect to this international obligation, I was suggesting that maybe the obligation to give effect to the general presumption you give effect to international obligations might be outweighed.
Well, I'm coming on. I mean, if I can persuade your lordships that this is a breach of Article 34, the second question is how does that apply in the national legal system? And my answer will be to submit to your lordships that and your ladyship that the common law will march consistently with the international law obligations of the United Kingdom unless Parliament has expressly or by necessary implication conferred a power on the judge to depart from the international obligation. And I say there's no such power. I entirely accept it's open to Parliament to confer expressly or by necessary implication a power on the domestic law judge to say whatever is said in Article 34, the judge, have a power to prevent the appellant or someone like him from communicating with Strasbourg. My point is there's no such legislation that expressly or by necessary implication does that job.
I'm just wondering whether the premise to this line of reasoning is necessarily the right one. We've been discussing in the last few minutes whether the domestic judge may say, well, the national security risks are such that I shouldn't allow this material to go to Strasbourg, whatever the effect may be on the international obligations of the country. But correct me if I'm wrong, my understanding that Mr. Justice Ouseley didn't think the decision that he was taking was in any way inconsistent with the country's international obligations, because he couldn't see that the material, not being able to disclose the material, would hinder the effective exercise of the right, which of course goes right back to the whole question of the entitlement of fair trial. It had been precisely because the court had consistently considered that the right to a fair trial would not be impeded by having it in camera, they went ahead. If that's the right analysis, what is wrong with, or where is the international breach if the judge is persuaded on grounds which at the moment you're not in a position to challenge, that this would not hinder the effective exercise of the right?
Well, I can challenge. I'm not accepting the judge's right to say that this restriction would not hinder the effective exercise of the right of individual petition. I've not accepted that at all, my lord. No, what I've accepted is I cannot challenge the judge's finding that there would be real national security concerns if this material was sent to Strasbourg. But I certainly do not accept that if and to the extent that the judge has found that Mr. Wang Yam does not need to present the sensitive material to Strasbourg in order to advance his case, that the judge is right about that. Absolutely not, my lord. I mean, it is fundamental to the applicant's case in Strasbourg that he wants to tell the Strasbourg court what is in the sensitive material so he can advance the claim that that issue, the issues relating to the nature of the sensitive material were such
but
that
what he
there
wants,
was a breach of Article 6.
What he wants and what he needs in order to be able to exercise his right effectively are not necessarily the same thing, are they?
No, but I'm putting the case on the basis that the whole point of an Article 34 petition is that the applicant must be able to put before the relevant court such material as he believes to be relevant to his case without the respondent state, which of course has a very real interest in the issue, being able to impede him.
But do you have a difficulty on the basis this case has come to us, on the ground that you accepted, quite understandably, earlier on, that if it was way off beam and clearly not relevant to his case, then you could say he hadn't got the right to rely on it and put it in. Add to that the finding that Lord Tilson has put to you, made by Miss Justice Ouseley. Are we not arguably in that territory?
Well, I'm accepting that if it's manifestly way off beat. It self-evidently has nothing whatsoever to do with the Article 34 petition. Then of course, I'm not arguing for something that is absurd in its nature. But here, the whole point of the Article 6 complaint is that part of my trial was heard in private, and given the nature of the information that was heard in private, that damaged my right to a fair hearing. And it is very far from absurd for Wang Yam to take the position that in order to develop effectively that argument, he needs to tell the Strasbourg court what it was that was heard in private, so that the court, as did the Court of Appeal, understands the nature of the information when it forms a view on whether there was a breach of Article 6. This is central to the Article 6 complaint. It's not something that is manifestly removed and different from the substance of the Article 6 complaint itself. And this was set out in the application to Strasbourg. We made it very clear that we were hindered in our ability to present the complaint. Appendix Part 2, MS page 171.
Internal page, or was that
Internal page 94.
Thank you.
Appendix Part 2.
Sorry, what was the MS reference?
MS page 171, Lord. Internal page 94 of the appendix. This is our application to Strasbourg, where we set it out in bold, the second new paragraph.
The decision to hold.
Yes, the decision, and then paragraph 18, therefore in outline only, with the omission of a significant aspect, and we set out what we're able to say publicly. And in our response to the government submissions, also MS page 199, internal page 122, this was our reply.
Thank you.
We said at paragraph 5, the applicant cannot fully argue his case without referring to the in-camera material. And I emphasise...
So you say that the test is not what a judge thinks on looking at it, even the judge who had dealt with the trial. It's you look to see this is obviously ridiculous. If he wanted to put in evidence that had nothing to do with anything on its face, that would be out.
Yes.
But once you're clearly into the res gestae, as it were, that's different.
That is my submission,
Understand.
because the whole point of Article 34
Understand.
is that it is the Strasbourg court which decides. Strasbourg may take a different approach, it often does, to the views taken by the domestic judges.
Yeah,
and unless
why isn't it for the Strasbourg court to decide this point now? Then, I mean, we have findings from Mr. Justice Ousley that there wouldn't be a breach of international law. The Court of Appeal, the Divisional Court, more or less endorses that, but doesn't primarily base itself on that. Now, why, from this point on, should we proceed on the basis that there will be a breach of international law?
I'm only asking your lordships and your ladyship to proceed on the basis that Article 34 entitles my client to put his case afresh to the European Court of Human Rights, so that it can form its own judgment on whether or not there is a breach of Article 6. And it is no answer, in my respectful submission, to my contentions about the importance of the Article 34 right and its scope for it to be said that English judges have taken a different view. It's the whole point of an application to Strasbourg, to have another look at these matters. And unless Wang Yam is able to put before the Strasbourg court the material on which he relies, then the efficacy, the value of the Article 34 petition with the right to have Strasbourg pronounce is undermined. That's my case.
Can I ask you just to make submissions about two particular things which
Yes.
Mr. Justice Ousley said, which are rather relevant to the points just put to you. First is beginning of paragraph 52 of his judgment, which is Appendix 1. I don't have the MS number, but it's internal, page 36.
Yes, my lord.
And the other one is paragraph 64. Now, first, paragraph 52, he says he's not satisfied. The course which the government may take is necessarily bound to breach its international obligations anyway.
Yes, my lord.
And then he comes to develop his thinking about that.
Yes.
And in particular, paragraph 64,
Yes.
he says that he's seen amendments to the draft suggested by the government, that's to say the response that the applicant wants to put in, which the government wouldn't contend breach the order.
Yes.
The amendments would permit the response document to be submitted. It would convey something of a flavour in the submissions. If the application on that basis were declared admissible by Strasbourg, I doubt that they could all be effectively pursued, let alone answered, without the in-camera material. But with the amended response document, the Strasbourg court would be in a better position to judge relevance and what requirement, if any, it should place on the UK government in relation to the in-camera material. As far as I understand it, that suggestion hasn't been pursued. No. But these questions are relevant to the question whether Mr. Justice Ousley was required as a matter of law to rule that not letting Mr. Yam do what he wanted would of itself necessarily involve the UK in a breach of Article 34.
Well, I am prepared to accept, as the judge said, that if the government vetted the application, then more could be communicated to Strasbourg than if they didn't vet the application. What I don't accept is that it is, with respect to the business of government, to vet the material that an applicant to Strasbourg wishes to put before that court. It's not, my respectful submission, the business of the judge, if I'm right, on the meaning of Article 34.
In short, your answer to my question is the judge was wrong, that he ought to have held that no ifs and buts, not letting him put before Strasbourg what he wants to do, irrespective of its relevance and irrespective of all other considerations, is ipso facto a breach, or will cause the government to be in breach of Article 34. It's as clear as that.
That's my submission. If one has a system in which people can make applications to a court alleging breaches of their right, it is absolutely fundamental to that system that they must be able to put before the relevant court that material which they contend supports their case, so that the court here, the Strasbourg court, is able to pass judgment on it. And I respectfully submit there's nothing surprising about that proposition. It is elementary in the context of a domestic court, and Article 34 is simply an international application of a principle that I say is fundamental to any court system. Accepting as I do, my Lord Towson's point that one might have different courts that look at matters from time to time, but you must be able to put your case before the court which has jurisdiction, and that's what we're doing.
That's regardless of the strength of the point in the second sentence of paragraph 50. Is it? Because one of the curiosities of this case, it'd be much better if this case had proceeded one step at a time, because who, on your analysis, is going to consider the points referred to by Mr. Justice Ousley in the second sentence of paragraph 50, which is the...
Paragraph 50 of Mr. Justice Ousley.
Yes, the point that the closed schedule explains clearly why material should not be made available to the Strasbourg court. I mean, who is going to adjudicate upon that? On what material? On your analysis, nobody is. You've simply got a right to put it there, regardless of what the risks might be.
Well, but my case in this court is and has to be that however strong the national security concerns, if you sign up to a Strasbourg system of individual petition, then there is a right to put material before the Strasbourg court. And I emphasise this is the appellant's material. There's no question that this material has somehow been disclosed to him in domestic proceedings under some obligation of confidentiality. There's no question of that. This is information that he knows and has known since before the criminal proceedings began. So there's no complication of obligations of confidentiality or something of that sort.
Is that clear from the judgments? I had rather assumed that it was information that came to light in the course of the trial itself.
No, absolutely not. We've made that position clear in our material, and there's no suggestion in any of the judgments that Wang Yam has acquired the sensitive material as a result of these criminal proceedings, or indeed any other proceedings. He knows this information. It was his defence case that he wanted to put forward as an explanation for the dishonesty that was said against him. He said, I have an explanation. Here it is, his information, his material. And that is what he wishes now to put before the Strasbourg court.
I thought he also wanted to put the material which the government had introduced in rebuttal.
No, he wants to put before the Strasbourg court his information. And if your lordship had inferred from the material that the information which Wang Yam wishes to communicate to Strasbourg is material that he has acquired as a result of being prosecuted, then I respectfully say your lordship is wrong.
Where do we see that?
I'll have to find your lordship.
You have correctly identified the misapprehension, but I'm not absolutely sure where we find.
No, well, I need to give your lordship a reference. I had not understood that was in any way in dispute, that it is Mr. Wang Yam's material, and we have so stated in our printed case. But rather than take time on trying to find that reference, I will have to give it to your lordships at a later point.
Lord Baron, I'm sorry to hold you back, and I'm conscious you're in
Not
the
at all.
first of your four propositions. But Mr. Justice, I think this is rather important. Mr. Justice usually had in mind some sort of iterative process. Given the premise, which you're forced to argue the case on, that there really were serious grounds for national security concern, what is wrong with the idea that there should be an iterative process of this kind with a view to trying both to preserve national security and do the maximum to enable his case properly to be heard? That might involve stage one, an amended form of his response going in. Stage two, Strasbourg consider, decide whether they're going to regard it as potentially admissible or not, possibly some further questions. What's per se contrary to our international obligations for the matter to be handled in that sort of way?
Well, I'm not complaining about the process in the domestic courts that Mr. Justice Ouseley proceeded in the way he did, in the sense your lordship puts to me. My complaint is that Wang Yam is not allowed to present his complaint as to a breach of Article 6 in the terms that he sees fit. That's the complaint. And in order to advance his Article 6 complaint, he is properly entitled to take the position, I want to put before the European Court all material that I consider to be relevant. Article 34 allows me to do that.
But if assuming that you're right to say that this was information that he always had, then this appeal raises an even more fundamental question, namely, if your client could not have been prevented before the trial from disclosing material that was already known to him, does the mere fact that that material is then deployed in a trial entitle the court to prevent him from doing something that he could perfectly have lawfully done beforehand?
Well, your lordship is right. I suppose that had the Attorney General learnt that Wang Yam outside was going to give this material to a national newspaper, then the Attorney General may well have applied for.
Well, one can see that there might be a basis for that if it was derived from some confidential source in which the government had an interest, a question which we know nothing at all about. But there isn't a general right to prevent people making disclosures contrary to national security, assuming that the government has no interest in the source from which it came.
Well, there obviously was, looking at the Statement of Facts and Issues, paragraph 2, the order was made for in-camera proceedings in the interest of national security and for the protection of the identity of a witness or other person.
Right.
Yeah.
So clearly someone was trying to or needing to disclose or call as a witness a person whose identity who would be endangered.
Well, indeed. There is a reference in our printed case to the fact that Wang Yam knew of this information prior to the criminal proceedings. If the court will go to our printed case,
Yes.
and it is MS page number 49. It's page 14 of our printed case, Appellant's printed case. At the top of the page, subparagraph 1 of paragraph 38, second line, the question is whether the authorities of a state can prevent the appellant as the applicant to the European Court from submitting to the European Court as part of his application information known to him prior to the criminal proceedings in which he has lawfully acquired. There's also a reference, what was that reference, Kirsty? There's also a reference in the judgment of Mr. Justice Ousley. What was the reference?
We're getting into very murky water here. Once raises the issue, we don't know what the facts are, we don't know why the order was made. It does appear from what Lord Mant says that it was at least to protect a witness.
Or some of it.
Or someone.
In connection with the proceedings, and presumably that protection still needs to be, in the court's view, continued.
That was the view of Mr. Justice Ousley, and...
But it is to do with protecting the trial process in some way. Whether, if he'd wanted to announce it in a newspaper before or not, he could have done, is a matter that we just don't know about.
No, the court doesn't know.
Lord Appellant, you said... sorry to interrupt.
No, not at all.
No. A moment ago you said that the last sentence of Article 34 really is absolute and you can't accept that there are any exceptions. I mean, one can postulate, of course, other yet more extreme situations, e.g. where somebody says if you submit this material to Strasbourg, then Parliament will certainly go up in flames tomorrow, if that was a realistic threat. But let's just take a different situation. You say it's an absolute obligation because it's an international law obligation, but normally international law obligations are simply obligations according to which we shape our laws and jurisprudence if they can be shaped, and they aren't absolute. It's perhaps associated with a different point, that adjudicating upon an international obligation here as to whether there would be a breach is quite a tricky and difficult thing for a domestic judge to do. But to leave that aside, even if one could be clear, isn't it right that international obligations are they're not binding at the domestic level, they're simply factors, maybe quite strong factors, but Parliament or the common law or the exercise of a common law discretion or a statutory discretion couldn't it arrive at a different conclusion?
I'm coming on to that. That's the second point. Can I finish the first one? Yes. I say, and I have to say, Article 34 is absolute. It is a breach of the international obligation. I say it's absolutely fundamental to the right to petition Strasbourg that you can put before Strasbourg that which you, the applicant, think is relevant. The European Court has so decided in Sysagiva. There are other cases that are mentioned. They're mentioned in both our printed cases on Article 38. And there is a range of jurisprudence that says that the European Court itself may require the respondent state to provide information. The European Court has that power. And I say that's a different power because here we, the appellant, are not asking for the European Court to exercise its power to require the United Kingdom to provide information. Our complaint is we have that information. We've always had that information, and we're prevented from communicating it to Strasbourg. So I won't take time on the Article 38 jurisprudence, but I mention it because I know that it is relied upon. So that's the first
Can I
point.
ask you, Lord Panic, so far as concerns the point raised by Lord Sumption, as I understand it, we're being asked to approach the case on the footing that if one leaves out of account the European Convention, there was a proper basis under domestic law for making the order. Is that right?
No, my Lord, because my submission is that because it is a breach of the international obligations of the United Kingdom to impede my client's ability to communicate with Strasbourg, the common law...
That's not leaving aside the convention, though, which was my Lord's question.
I see, leaving aside the convention. Yes, leaving aside the convention. I apologise. It's leaving aside the convention. I am not disputing, I don't see that I can dispute, that the domestic court would have power to protect the national security interests that Mr. Justice Ouseley obviously thought were significant. My case depends upon two propositions, and I've made my submissions on the first of them, that it is a breach of the international obligations of the United Kingdom to interfere with the freedom of communication with Strasbourg. And then secondly, this is what I'm coming on to, and it's the question my Lord Mance puts to me. I also have to satisfy the court that if it is a breach of the international obligations, so what from the point of view of domestic law? And my friend Mr. Eadie, the Attorney General, says, well, that's all very interesting, but at best it is an international obligation. It's no part of the Human Rights Act. Article 34 is not incorporated as part, and I accept all of that. And therefore, in order to make my case good, I also have to persuade this court that in the context of a human rights international obligation, the treaty obligation of the United Kingdom has this force and effect in domestic law, that the common law will be interpreted consistently with the international treaty obligations, and a divergence of the law of this country, of this jurisdiction, from the international treaty obligations will be recognised by the courts only if Parliament expressly or by necessary implication has so stated. That is the proposition that I advance, and I do not accept, with respect, the idea that the international treaty obligations of the United Kingdom are simply something to be taken into account. I'm inviting this court to give the international treaty obligations a much greater weight in domestic law.
But we're talking about discretion, aren't we? Yeah? We're talking about the exercise by the judge of a discretion.
I don't accept that, Lord, with respect.
No, well, what you say, there's some implied limit on whatever the common law power is?
No, I put my case on this basis, that if I'm right in submitting there is an international treaty obligation, then the common law will only recognise that it is lawful in domestic law to depart from that international treaty obligation in the context of human rights if Parliament, expressly or by necessary implication, has so authorised. That's how I put...
Sim's point.
Yes.
You were saying your...
Maybe another way of putting either the same or very similar point. I mean, I'm just wondering, there is, as you know, a certain amount of Privy Council case law on the question whether due process can be said to have been observed if something has been done to interrupt unimpeded access to the Inter-American Commission on Human
Yes,
Rights,
yes. The death
which is a
penalty.
exactly.
Yeah.
They are death penalty cases, although the reasoning, as far as I can recall, doesn't seem to depend on the fact that they're death penalty cases. And they are, of course, cases in which the right to petition the Inter-American Commission is a purely treaty-based right. It has no domestic law foundation, but it's nevertheless been treated as part of the essentially of the domestic process of arriving at an ultimate conclusion. I mean, is that case law relevant, or is that too much bound up with the constitutional provisions of the jurisdictions in question?
Well, it is bound up with a constitutional right to due process, but my argument is that the Sims principle, recognised by Lord Hoffman for the Appellate Committee, is a statement of constitutional principle in the common law. So yes, those cases are of assistance. My recollection is that they, with great respect to the board, they're not clear and consistent on the precise basis. Some of them turn on legitimate expectations, some of them turn on other matters. But yes, it is a recognition that where there is an international obligation accepted by the state, that an application can be made to an international court, there is an obligation on the state not to interfere with the ability to do so.
And that was said more or less in terms by Lord Millett in Thomas and Baptiste.
Indeed. Indeed.
On a related point, at paragraph 16 of the Divisional Court judgment, Miss Brimelow is recorded as having submitted that the position of the Strasbourg Court should be regarded as analogous to that of an appeal court whose access to material that was before the court below could never properly be impeded by an order of the court below. Is that a submission that you are making?
It wasn't how I was minded to put the case, no, because the Strasbourg Court has an original jurisdiction of its own. I mean, it is reviewing...
It's not an appeal court, clearly.
It's not an appeal court.
And I think this was being presented purely as an analogy.
Yes, as an analogy, it is a helpful analogy, yes, but it's, I wouldn't myself, and I don't understand that Ms. Brimelow was suggesting that Strasbourg has the role of an appeal court, but yes, it is a helpful analogy.
Well, Panic, we need to be rather careful about Sims, don't we? It's bandied about from time to time as authority for what it's not really about. Sims is a case and lays down an important but not new principle of statutory construction. You're contending something rather different. You are saying that where there is an international obligation with a human rights flavour, that automatically becomes part of the common law unless Parliament abrogates it to some degree. Now, that you won't find that in Sims. What are the authorities to support that proposition?
There are two distinct principles that I'm relying upon, and I'm relying on both of them. The first principle is that where there is an international human rights treaty obligation of the United Kingdom, the common law and statutory interpretation will march together with the international obligations of the United Kingdom. That's the first principle. The best statement of that, for my purposes, is the Queen against Lyons. It's Authorities, Volume 3, at tab number 20. Could I just take the court to that statement of principle? Queen against Lyons, all to do with the European Convention and matters prior to the coming into force of the Human Rights Act. And the statements of principle that I rely upon are by Lord Bingham.
So which bundle?
It's volume 3, my lord, and it's tab number 20. That's a very familiar, the case will be very familiar to the court. can I pick it up at 987?
Hang on, my 3 starts at 21.
It's page 1206.
Oh, yeah,
1206.
volume 2.
Yes.
Volume 3, sorry, no, you're quite right.
Yes, no,
Evidence page 1206,
yep,
but the law report 987, and it's a letter G. This is Lord Bingham, second sentence. It's true, as the attorney has insisted, rules of international law are not incorporated into national law, confer no rights on individuals directly enforceable, but although international and national law differ in their content and their fields of application, they should be seen as complementary, not as alien or antagonistic. Even before the Human Rights Act, the Convention exerted a persuasive and pervasive influence on judicial decision-making in the country, affecting the interpretation of ambiguous statutory provisions, guiding the exercise of discretions, bearing on the development of the common law. I would further accept, as Mr. Emerson contended, that the efficacy of the Convention depends on the loyal observance by Member States of the obligations they've undertaken and on the readiness of all exercising authority, legislative, executive or judicial, within Member States to seek to act consistently with the Convention so far as they are free to do so. Mr. Emerson, however, accepted that a Convention duty, even if found to exist, cannot override an express and applicable provision of domestic statutory law. And that was the issue in that case. Lord Hoffman is to like effect at page 992 in paragraph 27, just under letter B, third sentence of paragraph 27, it's firmly established international treaties do not form part of English law. English courts have no jurisdiction to interpret or apply them. That's J.H. Rayner. And at D, of course, there is a strong presumption in favour of interpreting English law, whether common law or statute, in a way which does not place the UK in breach of an international obligation. And there's a reference to Lord Gough of Cheveley in the Spycatcher case, which of course was a common law case. I conceive it to be my duty, when I am free to do so, to interpret the law in accordance with the obligations of the Crown under the Convention. Lord Hoffman added, for present purposes, the important words are, when I'm free to do so, the sovereign legislator is Parliament. If Parliament has plainly laid down the law, it's the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. So that's the first principle, and I respectfully submit it is a much stronger duty than a suggestion merely that judges will have regard to international obligations. They will do more than that, in my submission. The second principle upon which we rely is the Sims principle, and it is a principle particularly relevant to human rights as to the way in which courts will interpret statutory provisions, and my submission is a fortiori the common law. The Sims principle, well, its more recent manifestation, although there are many other cases since, is Morgan Grenfell, Authorities Volume 3, the same volume, tab number 19, the tax case, and the statement of principle is by Lord Hoffman speaking for the Appellate Committee. Of course, he was speaking for himself in Sims, but in Morgan Grenfell, he approves what he himself had said and what Lord Steyn had said in Sims, and it's page 607 of the law report, MS page 1182.
Thank you.
Paragraph 8, where Lord Hoffman says the courts will ordinarily construe general words in a statute, although literally capable of having some startling or unreasonable consequence, such as overriding fundamental human rights, as not having been intended to do so. An intention to override such rights must be expressly stated or appear by necessary implication. Then he refers to Sims, and he says the wider principle is hardly new. So that's the second principle on which we rely. And we say that in a human rights context such as this, where the international obligation is a human rights obligation, that's the first principle, the Lyons principle, the courts will be especially concerned to ensure that the Sims principle is maintained, and that if there is to be a breach of a human rights principle, particularly one that derives from an international obligation, Parliament must say so expressly or by necessary
Is this whatever the limits? I mean, whatever the risks say to national security?
Yes, that's a matter for Parliament. In my submission, it is open to Parliament to say we are concerned that Wang Yam and people like them can, because we've signed up to Article 34, they can put before Strasbourg material which is very damaging. And therefore, we, in domestic law, will enact a power on the courts to stop them.
Why is it a matter of Parliament? I mean, we're talking about, I think the divisional court said, a statutory discretion, probably, rather than Section 11. So if we're talking, about common law discretion,
yes.
then you don't expect Parliament to go around enacting all the qualifications on the discretion. Or it's a matter for the judges to give effect to this principle, if you're right.
Well, it is a common law discretion. It is a common law matter. My friend Mr. Eadie accepts in his printed case that the statutory provisions add nothing.
Yeah.
Essentially, I hope I don't traduce his submission, but that's essentially what it comes to.
It's
So it's a matter of common law.
That's normally something that the judges shape.
Indeed.
There's no need for parliamentary intervention.
And my submission is that the Lyons principle applies, that the common law must be interpreted consistently with the international obligations of the United Kingdom unless Parliament has stepped in and has given authority to the court to act contrary to the international obligations. I respectfully submit it's not a matter for the judges, of the common law judges, to say, well, that is an international law obligation, but we believe that other factors outweigh that international obligation. That's not the responsibility, I say.
Just pause a minute. I mean, Lyons is a common law principle, isn't it? What you're saying is that the judges who've shaped the common law are influenced in its shaping by our international obligations in the human rights field. You're entitled to rely on Lyons for that. The second point, I just don't see that Sims has any relevance in this area, because if the common law does not go to a certain point, then it isn't fundamental. And if the common law does go to that point, well, then you've got it. So, I mean, Sims has, as I say, an important part in statutory construction. But when you're simply looking at how far has the common law gone, where should it go, it doesn't help you. Lyons does help you up to point. The question is how far, isn't it?
Well, can I seek to explain why I say Sims adds something as a relevant second principle? And it is this. If Parliament had enacted a general power on the judiciary to impose restrictions on individuals, then the Sims principle would require the court to ask itself whether or not the interference with human rights had been stated expressly or by necessary implication. It's a strong constitutional principle.
Before Sims came into play, the court would first of all be asking itself whether, as a matter of common law, there is some right which is regarded as fundamental.
Yes.
If it is satisfied of that, then it says, well, we must read the words of the statute extremely carefully. Question we're concerned with in this case is whether there is a fundamental common law right of the kind for which you contend. If there is, you're quite right in saying that there isn't a statute which abrogates it. If you're wrong, well, the absence of a statute is irrelevant, isn't it?
The Sims principle I say assists for this reason, that if the constitutional principle in Sims applies to statutory interpretation, it must also apply in the field of the common law. The same protection of human rights must apply in the common law. But I take your lordship's point that my argument depends upon satisfying the court by reference to Lyons that there is an international human rights obligation which the common law will protect.
Sims presupposes a common law. You can't use Sims as a bootstrap to create a common law fundamental principle.
No, I'm not seeking to do that, my lord. I'm simply seeking to respond to the argument against me that the common law has a weaker than I'm submitting respect for human rights obligations. That's the relevance of Sims, that it is a constitutional principle of the common law manifested by Sims and many other cases, that the common law will give strong protection to questions of human rights. And if that is so in relation to statutory interpretation, I say it's a fortiori in relation to the common law. And I say that supports the contention that where there is an international human rights obligation of the United Kingdom, the court will require Parliament, expressly or by necessary implication, to have approved of some deviation from it. That's the submission.
That's carrying the presumption. It's turning it from something other into something other than a presumption, isn't it? There's a world of difference between allowing international law to influence, even strongly to influence, what you think the common law is, and treating international law as the default position, which applies as part of English law unless excluded by statute. When the latter involves a considerable further step beyond the presumption, which Lyons doesn't, on the face of it, justify.
Well, Lyons does say that so far as the judge is free to do so, which I understand, I submit, means provided there's no binding authority or there's no statutory provision to the contrary, the judge who is applying the common law should seek to arrive at a decision consistent with the international obligation of the United Kingdom.
Can I just, go back to first principle, because I remember a case in which my lady and I were involved, Hurst, many years ago, and yes. we dissented on this point, and the majority said that the general principle is that a domestic decision maker exercising discretion is not obliged to exercise it in accordance with this country's international obligations, but he or she may do so, and if they do so, then the court may or will check whether they did so consistently. But I think the point we had in mind there, and it's been referred to in other cases, is that Lord Steyn has advanced the proposition, and one has sympathy for it, that in international fundamental human rights context, decision makers should exercise their discretion in accordance with yes. The international conceptions of human rights to which this country is signed up. But so there's one does start from a slightly opposite end to the one you've been advancing, doesn't one? Admittedly, one may get back very close to where you are in the human rights context, but it really goes back to my Lord's point, how firm or extreme or absolute a fashion does one state the principle?
Well, I have to state the principle in strong terms on behalf of my client, and I do. And I submit it is not, with respect, a question of discretion. The question before this court is whether the judge has power. Does he have power to make the order that he made, restricting the ability of Wang Yam to make the application in Strasbourg in the terms, by reference to the material, that Wang Yam wishes to refer to? And my submission is and has to be that the judge had no power. I'm not complaining that the judge didn't weigh the relevant factors. I mean, once the judge is entitled to look at national security factors, then my position is hopeless. I cannot possibly challenge the reasoning of the judge on national security grounds in this court when I don't know what the material is. And I put my case on the basis there is simply no power. Why is there no power? There is no power because it is a breach of the international obligations of the United Kingdom under Article 34 for the judge in any circumstances to restrict my client's communication of information known to him, not obtained by under conditions of confidentiality in a trial, but known to him. It's a breach of Article 34, and I submit, and I have to submit, that the development of human rights law in this jurisdiction is such that the courts will now, if they haven't previously, they will recognise that where there is an international human rights obligation of the United Kingdom, both as a matter of statutory interpretation and as a matter of the common law, the court has no power has no power to act in a way inconsistently with that international human rights obligation, except where Parliament has expressly so authorised the court, or by necessary implication. Or, I suppose, if it's a lower court, it's bound by some higher authority.
It's putting rather more strongly than indeed in the passage which you quote in your printed case after the citation of Lyons at MS 44. You go on to cite what Lord Bingham said in A and the Home Secretary. Yes. Your submission ratchets it up rather, doesn't it?
Well, there are various statements of principle that we've referred to, some of which put the matter more highly than others. And I've referred to Lyons because I say that is the applicable principle. In many of these cases, it hasn't mattered how strictly one puts how powerfully one puts the point, because they are cases where the answer is derived, whatever the precise nature of the statement of principle. But it does matter in this case. In this case, it vitally matters what is the relationship between the international obligations of the United Kingdom and the common law. That is the second issue, if, but only if, I'm right on there being a breach of Article 34. What are the implications of that? And I repeat, I am accepting, as a matter of course of constitutional principle, it is open to Parliament to take such steps as it sees fit if it, Parliament, is not satisfied with the implications of the Article 34 obligation. But it's taken no steps in that respect. So those are the constitutional principles I rely upon. And again, in answer to my Lord Torson, I'm relying on Sims because Sims is a manifestation in the context of statutory interpretation of just how important human rights obligations are to the common law, to the way in which our legal system has been developed. So that's how I put our case in relation to these matters. I accept that the statements of principle as to the relationship between the common law and international human rights obligations are varied, but I say in principle, and by reference to Lyons, the correct approach, in my respectful submission, is to adopt a strict approach. And I say that's appropriate given the importance of international human rights obligations. It's particularly important in the context of an international human rights obligation of access to the international court that determines whether the substantive rights of individuals have been breached. So that's the second part of my argument. The third part of my argument I can deal with very briefly. If I'm wrong so far, then that's the end of the case. But if If there's any substance in what I've said so far, then there is no express parliamentary conferral of power on the judge, relevant power on the judge, and it doesn't derive by necessary implication from any statute. The common law is silent on this question of can a judge restrict an individual, if I'm right on Article 34, from exercising what Sysagiva calls a right under Article 34 to communicate information to the court. And the fourth point I've dealt with in substance already, the point as to consequences. The printed case for the Attorney General says, and one understands why it so states, that if we were right, it would be both surprising and disturbing, paragraph 26 of the Attorney's printed case. One is reminded of one of the authorities in the bundle, the Leach case, the case about judicial review of prison administration, Authorities, Volume 2, Tab 12, it's page 566b, where Lord Bridge said of a submission by one of Mr. Eadie's predecessors, John Laws, that it was, I quote, designed to make our judicial blood run cold. Well, we submit that the judicial blood need not be disturbed in this case, that it is not for Mr. Justice Ouseley to protect national security concerns unless Parliament has conferred a relevant power. And the government may invite Parliament to confer a relevant power if it is unhappy about the security of the procedures in Strasbourg, if it doesn't have sufficient confidence in the Strasbourg system, or, for all I know, in the personalities of those who work there. These are matters, I say, for the government to invite Parliament to act on, and not for the court to assert a power that has not been conferred expressly or by necessary implication. Have you got a list of references to where it's been said that we knew of this information right from the start? But it's not information we've acquired during the trial. We had a list of references.
Yeah, I did.
No. I'm just seeking, Ms. Brimelow has prepared
It's just in there. It's in
references in the judgment of Mr. Justice Ouseley to the fact that the information was not acquired by my client as a result of the trial.
Well, if you accept, as you did in answer to the question from my Lord Reed, that domestically and quite apart from any Human Rights Convention points, there was a proper legal basis for the order, then that probably doesn't arise.
That issue doesn't arise if...
the question whether it was derived from the trial itself or previously owned or whether, so far as previously owned, it related to the protection of witnesses or to something else.
No.
These are all points that if you accept that there's, on purely domestic terms, a proper legal basis for the order, would appear to have no significance.
No, but its significance, I would suggest, is to the proper application of Article 34, because it's no part of my case that there is any absolute duty on the United Kingdom to provide information. Under Article 38, the Strasbourg Court may request information from the government, and for all I know, may do so in this case. But my point is that Article 34 must entitle the applicant to put forward such information as is in his knowledge and has not been acquired as a result of a confidentiality assurance that he has given. If, and to the extent the court is interested in this, it's set out in the judgment of Mr. Justice Ouseley at paragraph 12, which is Appendix Part 1, MS page 104.
104.
Yes, paragraph 12. I won't read it out.
Well, I don't get quite what you're submitting from paragraph 12. And it starts off that the in-camera order related to part of the evidence put forward by Wang Yam, but then it goes on, none of the prosecution's evidence to establish his dishonest involvement in response to it was heard in camera. The prosecution evidence heard in camera rebutted Wang Yam's explanation for such involvement as he admitted. So, I mean, doesn't that suggest that the prosecution also was adducing some sensitive evidence?
Yes, they did, and it's, of course, entirely a matter for them what they want to put before Strasbourg. But all we want to put before Strasbourg is our case. And our case was not based on anything that we learnt during the criminal proceedings. That's what we want to put to Strasbourg, and that's what we're being prevented from putting to Strasbourg. So I say this is a unique case, but it does raise very important questions as to the meaning of Article 34 as an effective right to petition Strasbourg, and it raises very important questions as to the relationship between international human rights treaty obligations and the common law. I notice the time. That's what I want to say on behalf of the appellant, subject, of course, to any questions that the court may have for me.
Well, we put a lot of questions to you, Mr. Panic. Subject to Miss Brimlow, I suggest that if there's anything you want to add at 2 o'clock, you should have the opportunity to do so. But subject to that, thank you very much. Miss Brimlow.
Thank you very much.
Good. We'll resume again at 2 o'clock then. Thank you very much. Court's now adjourned. Sorry.